Hi, this is Sally Flashberger with the Wisconsin Board for People with Developmental Disabilities. We're here today for another Living Well Wednesday, and we're excited today. We're going to be talking about supported decision making, and we have some great experts and family members here to help us out. We're going to hear from George Zaski. He's an attorney, but also a parent. And will be giving us all the information about the law. Then we're going to turn it over to Mitch Hagopian. He's going to go into more about the law, but other ways that you can combine different supports around supported decision making. And then finally, we'll hear from Lisa Pugh. She's with the ARC Wisconsin, but she's also a parent. So she's going to talk about her experience with her daughter and supported decision making. So George, I'm going to turn it over to you.
Good morning, everybody. I'm glad to be here. As Sally mentioned, I am an attorney, but I always like to say, more importantly, I'm the parent of an adult son with a cognitive disability. And I was involved in the very dedicated group that drafted the language to the law, which is Chapter 52 of the Wisconsin statutes. Now, I'm not going to spend a lot of time, doing the lawyer thing. I'm going to talk a little bit more about what I've done in terms of my role as a supporter for my son. And when we first started using the concept of supported decision making, we were in fact before the law. And we struggled as a family of whether or not to go with guardianship because there was no supported decision making law. And was a guardianship appropriate? And the research and the reading that I have done indicates that guardianship can be detrimental to a young person's development. Our physical brains as human beings, whether you have a cognitive disability or not, is still developing, growing. Neural pathways are being laid down age 17 and a half to 20, 24, 25 years old. So that really is important, according to the research, that people have an opportunity to make decisions, have an opportunity to fail safely, if you will, so that they can continue to develop impulse control, develop better rational decision making. And what the studies have shown is that guardianship can in some ways cut that off, because people who are under guardianship have an awareness that somebody else can make, and oftentimes does make, the decisions for them and not include them. And when we first started looking at this, we went partway down the guardianship process. And we, after some soul searching and an experience with the doctor, decided that's not the way we wanted to go, that we in fact were going to go with other documents that Mitch will be talking about later, but we were going to use the supported decision-making approach. And I was going to take the role of supporter. And one of the first things that we did is look at opening an ABLE account. And here's where I do a little segue. And my PSA that I do in every presentation I give is, if you don't have an ABLE account for your loved one, or if you're a self-advocate and you don't have an ABLE account, I encourage you to look at it. It's an option. As an estate planning attorney, I work with families and I tell them, before you draft a supplemental needs trust, take a look at an ABLE account. It can give you, I think, a lot of flexibility for the future. And so that was the thing that we were looking at. My son had signed up for SSI, Supplemental Security Income. Because of the delays in the system, he had a rather large, what they call a back award. And so he had some money that if we didn't do something with, he would run afoul of the rules for maintaining his benefits, because in fact, he would have been what's called over assets. So he would add more than $2,000 in an account in his name that was not an ABLE account. And an ABLE account is designed to help people avoid that impact. There are rules around it, but there's a wonderful website that you can go out and check, the National Able Resource Center.org. If you search for it, you'll find it. It's really got a lot of really good information, and I encourage you to go out and look at that. But this was a number of years ago, and my son and I, we talked about, you know, the importance of saving money, the importance of putting aside resources so that he could have options in the future, as opposed to just blowing through that money and buying another pair of shoes or something along those lines that really wasn't long-term beneficial to him. So we talked about signing up for ABLE, and going through that process, we decided that we would do a telephone application process. So there was one of the ABLE providers that allowed for that. So I had him dial up, and it was after we had talked about what he was going to be asked and the information that he was going to need, and he felt comfortable with that, and giving him control for setting up this account. Tried to anticipate every question that we could, which is something that as a parent and as a supporter, we always try to do, right? We always try to anticipate every scenario that's out there. So we got on the phone, and he started the process. And we got to a question that I hadn't anticipated. And so he said he wanted to ask his dad, i.e. his supporter. Well, again, remember, there's no supported decision-making law in place. This is just a father, a supporter, trying to help an individual with a disability do one thing. And that's the benefit of a supported decision-making agreement. You can really tailor it. And I'll talk a little bit more about that later, but you can really tailor it to individualized situations. But when we went through that process and he had to pause and say, well, I need to talk to my dad, that put the person on the other end of the phone in sort of a questioning mode. And because there was an assumption, if you're opening an ABLE account, you have a disability. That's what they're there for. So it's a reasonable assumption. But it's there for people who have physical disabilities, who have other disabilities besides just cognitive. And they didn't want to proceed with the application without they were asking for a power of attorney. Now, as an attorney, I know they couldn't do that. They couldn't require that as a matter of law, but my experience has been that you get with some of these big organizations and they will have their own rules that if you want to work with them, you have to, in a sense, acquiesce. So I already had a power of attorney in place. And so we had to sign off the call. I had to pull up the electronic record and send it to them so that we could then go in and set up the ABLE account. My son could set up the ABLE account with me in support. But that's what the organization that we were interacting with required. These bureaucracies, be it education, financial, even medical, they have their processes and procedures, and part of it is what we refer to sometimes in the law as papering the file. And so I realized that there was going to be some difficulties going forward with the supported decision-making concept without something in place that would be officially recognized. So there, as I said, there was a group of very dedicated and smart people that got together and drafted the language for Chapter 54 that outlined supported decision-making as well as the role for the supporter, and also then provided for protections for people who accepted supported decision-making documents. And that is one of the things that we realized, like the bank that we were trying to work with for the ABLE account setup, is they needed something. And they were used to either seeing a guardianship order or they're used to seeing a power of attorney. So this gives these outside entities some liability protection if they go forward down this path. And it's a very easy form. Before this meeting, I thought, oh, I don't have a copy of it. It's in my file. And so I just went out online, did a quick search, and it's, four pages long. But what it does is it helps you as a self-advocate focus on an area that you need decision making. And one of the examples I use is my son is a gamer. And I have over time had to learn about gaming systems. I guess a PS5 is coming out now, or the Xbox, or the Nintendo Switch. There's so many, it can be overwhelming. And it would be nice, in my mind as a parent, to have somebody else help my son decide if he needs a new gaming system. And you could have a choice that simple, that straightforward. And he could identify a friend to say, hey, would you help me gather the information to be able to identify which would be the best gaming system to meet my needs? I will make the decision. You won't make the decision, but you'll help me. You'll help me search on the internet, or maybe we'll go to GameStop together. But that way you can outline for the supporter what it is you're asking of them. It can be time limited. It can be narrow in scope. And it's a very easy form to fill out, but it's a little more formal, I think, in terms of helping a person with a disability be focused on what they want help with. And I think it also allows a supporter to then say to themselves, oh, I'm just being asked to do this narrow thing. I'm not asked to be a guardian. I'm not asked to take on more than I can right now. And you can have as many of these agreements as you want in multiple areas. And it's really straightforward, but it does require some intentionality around it, where you have to sit either around a kitchen table or at a coffee shop or somewhere where you can talk with a person with a disability, or the person with a disability can say to their potential supporter, this is what I need help with. And you can articulate it, you can fill it out, and then there's some formality around it in terms of the person with the disability signing it, saying this is a supporter, I want them to help me with a gaming system purchase. And then the supporter signs on, and you sign in front of either two witnesses or a notary. And then that can be something that you have as an agreement that is valid under the law. Now, I'm using a simple example of a gaming system that maybe you'd never put that in a file. But if you're going to work with a bank, or you're going to work with a medical provider, or you're going to work with an education institution, that can be something that they can then put in their file. And then that institution knows that if they make some decisions based on that, in terms of either accepting an application or some other action that they take, and somebody then says, well, you shouldn't have done that because this person has a cognitive disability, they have something in their file that says, no, they came in with a supporter. They said they were going to make their own decision, and we recognized that, and we gave them that respect and allowed them to make their decisions. So this is new. We're still getting used to it. We're hearing different stories about how it's being used, how it's not being used. It's not a silver bullet. It doesn't handle all situations, but it certainly is a significant step forward in my mind as a parent who's tried to do these things, as well as an attorney who works with families that work in this arena. So it's been good for us. It's something that I encourage all of you to take a look at, and then you can continue to grow and develop more. And as more systems see this, I think the more progress that we're going to make. So I don't know if there are any questions. I'm kind of watching my time here so I don't go over.
Yep.
I know Mitch has a few things to say, and I know Lisa does. So.
I'll ask you a question. Just so you didn't have it for the ABLE account, but have you had to use it for anything else at this point?
To this point, no, we haven't had the necessity to use that because we haven't been interacting with, bigger systems. And on a sort of a personal note, we're still trying to identify people that can support him in smaller ways, and that's the area that we're struggling with quite honestly, as a family, is finding people who would be a supporter. So once we're able to do that, then I think I can work with that young person who, you know, is willing to work with my son to say, this is what we'd like to do, to give him those kinds of opportunities. But we use the supported decision-making concept and talk about, you know, him making choices and being involved. But we haven't been able to use it with another supporter, but that's for other reasons than the law and the form itself.
Sure. I'm gonna turn it over to Caitlin. She's just gonna pop open our BPDD toolkit. That'll give you, she can show it, and then we'll link it in the chat here and on Facebook Live, but she's gonna pop it open. I think she can do it. I gave her permission.
Yeah, just give me 1 second.
Yeah, I was going to say too, George, when COVID hit, my son and I did discuss doing the supported decision making. He said, yes, we should do it. And it was very simple, just a very simple process, which I thought was great.
All right, I've just pulled up the toolkit from our website. We have it, I will go ahead and share it in the chat. I just shared it on Facebook. So if you're on Facebook, this is the toolkit that is in the link. It's a really great resource. It walks you through some background information, the current decision-making tools, support tools that are out there and what they do. And then towards the bottom of the agreement, it gives you a really easy chart on how to fill out an agreement, where you need to get it signed by witnesses or by a notary, if that's the option that you are going with. That's a really great tool that helps you. And then they've got another link here for where agreement forms can be found, resources. It's just a really great tool. I'll go ahead and pull up what the actual, if you click on this link, this is the supported decision-making agreement that exists on the DHS website. So you can go ahead and get it there, though I do think that it is at the end of the toolkit as well. It is also in Spanish. So on our website, and I'll go ahead and put the website link as well, because I just linked right now to the full toolkit, but I'll put the link to the toolkit page on our website. It's in Spanish. So if you are a Spanish speaker, or your supporter is going to provide support to you primarily in Spanish, and you would like to use that agreement, sorry, I'm going through it pretty quickly, then you can go ahead and use the Spanish version as well. Yeah, I think that's, so this toolkit is a really great resource for you to use to walk through the process. Here we go. I knew it was at the bottom. I should have trusted myself in the first place. It's a really great tool that walks you through all the questions that you might have regarding filling out supported decision making, how to use. Though, of course, if you have other questions, you may feel free to reach out to BPDD. We'll try to help you with that. And then the last sort of 4 or 5 pages of the toolkit has the actual supported decision making agreement, and you can go ahead and print that out. And like George said, you can have several of these, so it might be good to have, you know, a couple of copies of this as you start to have these conversations.
Yeah, and I want to reiterate that that's one of the reasons why, you know, we wanted it to be a simple form, and it doesn't require any attorney to be involved. It can be something that you grow. You can, as I said, you can have multiples of them. They're out there online. If you have a computer, you can download it to your own computer so that you can print it off. You can fill it out with your hand. It doesn't have to be typed. The only formality that there is to sign it. And psychologically, there is some value in that, because it demonstrates to both parties, the person asking for the support as well as the person consenting to support them, that this is serious, this is important, and that they're acknowledging that. And I think they're acknowledging the idea that the person who's asking for the support needs it, but they want to make the decision. And this, I think, demonstrates to the supporter, whether it's a parent or a friend or an other family member, aunt and uncle, that this is your role, because some of these roles can get blurred as you go through life, between being a guardian or a parent or a friend. And so this is a way of having a little more formality around it, and then building the skills for looking to the future as we as parents step back more, or in fact may not be there. I think if we can help our loved ones develop this skill set and know that they have a tool that they can use and they have experience using it as they come up to new challenges in their life, they can look at it and say, hey, I need help. I need to be able to define it. And I need to be able to find somebody who will help me with that and respect me and help me along this particular path to make this decision, whether it's in using, what kind of apartment I want to live in, or if I want to purchase a car, or if I need help understanding perhaps a medical decision that needs to be made in future. So it's easy enough to get, and I recommend that you have multiple copies.
All right, thanks. There was a financial question, and it's probably not something we can answer today, but we are going to be doing a presentation in October around financial situations for adults with disabilities, and it's going to include the ABLE Act, so just look for that. But at this point, I'm going to turn it over to Mitch. You're on.
Thanks, Sally. Nice to be here with everybody this morning, soon to be afternoon. As Sally said, I'm Mitch Hagopian. I'm an attorney with Disability Rights Wisconsin. We're the protection and advocacy agency for people with disabilities in Wisconsin. And we're a partner agency with the Board for People with Developmental Disabilities and the Waisman Center over at the University of Wisconsin-Madison. So I'm here to talk to you about some of the other things and other tools that are available to people who might need some help with making decisions. And so there's basically several of them. Most of you, I'm sure, hopefully you've heard of all of them, but I'm sure you've heard of Guardianship. That would be the one that is kind of the one that's been around the longest. It's the most formal one, and it is the most restrictive one. And from our perspective, if you can avoid getting involved with that process, you should avoid getting involved with that process. Guardianship's appropriate for some people, but not for everybody. So we'll get to that one at the end of this, but I'd like to talk about some of the other forms that people can use to help them with decision-making that aren't as restrictive as that and that don't take away people's rights. Because that's what we like to encourage, is that, especially for people who are just, turning 18, who may have, cognitive disability of some kind, unless it's absolutely necessary, there are a lot of ways that you can help somebody with decision-making without getting them involved with the whole guardianship system. So here's a few of them. First things to remember, unless you are put under guardianship and found incompetent by a court, you're competent. You're presumed competent. It doesn't matter if you actually, can make decisions or not. You're, from a legal perspective, as soon as you turn 18, you're competent to do things. So that actually opens up some avenues to people. And there's different ways that you can, bring people into your life to help you make decisions without being subjected to guardianship. So first of all, there's releases. These are just documents you fill out. Typically, you use these with healthcare people and with educational people, schools and colleges and things like that. And basically what this is just a document. It's usually prepared by like the hospital or the doctor's office that you are working with, or the school that you're working with. And, excuse me, I need to take a drink of coffee. And this form basically allows you to designate someone to be able to access your medical records or your educational records. And for a lot of people, these two things are enough to help them with most of the major decisions in their life. Because if you can say, hey, I want my mother or my father to be able to see my health records and to talk to my healthcare providers, or I want them to see my educational records because I'm still in school till I'm 21. And I want them to be involved in my IEP meetings and stuff like that. That can all be done through just a release. You sign that document, and then those people can become involved in the decisions as long as you're, have told these other entities that you want them to be involved. And releases are good because all that does is say they have access to the information, they can be involved, but they don't actually take a right away. You're still in control of that. And if for some reason you get mad at your mom or your dad, you can revoke the release, take it away, and then they don't have access to it anymore. So that's a very simple way to, kind of deal with the formal process of having other people involved in some of these important areas of your life, education and healthcare in particular. So that's one way to do it. Another way, George talked about it, supported decision-making. This is, super informal. You have, in Wisconsin now, you have the document that you can use to formally designate someone to be your supporter. And then that document allows that supporter to have whatever access to information or participation in meetings that you want to. You kind of lay that out in your document, and then that document can be used to show healthcare providers or teachers or banks or landlords or whoever that you've designated this person formally to help you make decisions and you want them involved in it. And again, this is totally voluntary on your part. You fill out the form, you do it the way George described, and then it becomes part of your record if it's a healthcare provider or an educational provider, and it gives access to that supporter so they can support you as you're making decisions in these areas of your life. You can revoke it anytime you want. So, and while it's in effect, it doesn't transfer any decision-making authority from you to that supporter. They really are just a supporter. They're not a decision maker. So supported decision-making, releases, these are two informal ways of, getting help without actually transferring the decision-making. The supporter helps you, decide things, helps you process information, communicate things, however you want to use it. But at the end of the day, you're the one who says, I want to do this. I want this medical treatment. I don't want that medical treatment. You make that decision. The supporter doesn't make it for you. The person who you gave, access to your healthcare records through release, they don't make the decision for you. You keep that authority for yourself. Now, there's some other things where decision-making is transferred, but not to the same degree or in the same way that it is under a guardianship. So there's two forms that are pretty typical that people use. And both of these can be used by people who have not been deemed incompetent by a court of law. So, if you haven't been found incompetent and put under guardianship, you should be able to execute these documents. One's a financial power of attorney, which is George has talked about that. And that's basically just a contract between you and somebody who you trust to transfer decision-making authority over your financial matters and other legal sort of contract stuff. So this is a document you fill out. You decide, what parts of your financial life you want to transfer to that person. You sign it, and usually these kind of powers of attorney, they go into effect right away. But the thing about them is, so that means that if, like, I was to designate George to be my financial power of attorney today through his filling out one of these documents, George becomes my power of attorney, and he can start making decisions for me right away, even if I'm still competent. So basically, once you fill this out, typically, they're not all like this, but most of them are like this. They give that authority to the other person right away. And that person can make decisions you too can make a decision. But because it gives that authority right away, it's really important that the person you pick to be your financial power of attorney is somebody you really, really trust, because you don't want to give them, access to your bank account and then have them take all your money from you. So, and the other thing about these is, if later on you become incompetent, like maybe you have a head injury or something, and you no longer can make decisions, that power of attorney that you signed, that stays in effect, and the person you designated to be your power of attorney can continue to make financial decisions for you. And that's advantageous, because having that in place will avoid the need later on for what they call a guardianship of the estate, which is a kind of guardianship that deals only with people's money and their financial matters. So that's one way to do it. Like I said, it preserves your right to make financial decisions up until the point when you lose competency. When you lose competency, the person you've designated takes over for you, but it's not till later in the process. The other thing you can do is set up a healthcare power of attorney. And this one is different than the financial power of attorney, because with these, you designate someone to make healthcare decisions for you. But this kind of a power of attorney doesn't even go into effect. No authority is transferred to that person, we call them an agent, until you become what they call incapacitated, which is kind of like being found incompetent. So what that means is that, you designate, I'm going to designate Lisa to be my healthcare power of attorney. I fill out the document. There's a form to do this. And then I talk with Lisa about how I want my healthcare to go. I say, this document, if I need to go into a nursing home, I'm okay that you let me in. If I've been declared incapacitated and I can't make a decision and I need to go in a nursing home, you can admit me to the nursing home or to a CBRF. Or I can say, no, I don't want you to do that. Under no circumstances do I want you as my agent to be able to admit me to a nursing home, or I don't want you to do certain other things. You can put into that document exactly, what types of decisions you want that agent to make on your behalf. And that doesn't go into effect until, you're pretty ill, because 2 physicians have to certify you, or 2 healthcare professionals have to certify that you're no longer capable of making medical decisions. Up until those specific designations happen, you're the only one who can make medical decisions for you. So that comes in handy. You make the decisions up until you can't, and then there's someone in place who can do it for you. Now, this is something, that a place where then supported decision-making would be great, because until you actually are declared, incapacitated by 2 physicians or two healthcare professionals, you can use supported decision-making to actually make ongoing medical decisions. So I might designate Lisa to be my supporter for healthcare decisions. And so while I'm competent and I'm still the one who has to, give consent to the doctor to do a medical procedure, I can use Lisa as my supporter to help me decide which, between 2 treatments I might decide I wanted. So those are, those kind of powers of attorney are really useful tools. As long as you're still competent, you can execute them, which means, fill them out and get them certified by the right people so that they become legal documents. Another method that is not as restrictive as guardianship, but is not so great either, but it can come in very handy, and that's a representative payee. Representative payees are created by the Social Security Administration, and they're people who are designated to make sure that either your Social Security disability benefits or retirement benefits or your SSI benefits are not wasted. So if there has to be a decision that you're not able to responsibly handle your money, your Social Security or SSI benefits, and if that happens, the Social Security Administration will designate a person called a representative payee to basically make sure that you know, when you get that monthly check, it gets spent in the right places. It doesn't get wasted. You know, your rent gets paid, your utilities get paid, your telephone bill gets paid, as opposed to, you know, some people, they get the check on the first of the month and they immediately spend it on things and they don't have any left for food and for rent and that sort of thing. But that can only be imposed on you by the Social Security Administration. But that's still better than a guardianship of the estate in many cases, because they can only control the money that comes from Social Security. They don't control money that you might earn from a job or that you might get from some other source. So, but those are all things that can, you know, that are way less serious than guardianship. Now let's talk about guardianship, because a lot of people think that if you have a, you know, a cognitive disability, you're 18, well, you know, mom's been helping me make decisions all this time, so mom has to become my guardian right now at age 18, because otherwise something horrible is going to happen, you know, to me. Well, that's just, in most cases, not true. I mean, some people, and Disability Rights Wisconsin as a protection and advocacy recognizes that there are some people who need guardianship, you know, at age 18, because they really cannot make decisions, and none of the tools we've talked about can really work for them, either because they're just, you know, have the disability is so severe that they cannot, you know, make decisions, or they're making really, really bad decisions because of their cognitive disability. So it's appropriate for some people, but it should be considered a last resort, because here's what happens when you consider guardianship. First of all, you have to meet with a doctor, and the doctor has to go through and they'll fill out a form, and they'll say whether or not you can make decisions in all sorts of areas of your life. You know, where you live, where you can travel, who's going to make medical decisions for you, whether you can handle money. Potentially, it's everything about your life can be handed over to someone through a guardianship. And the thing about it is, because it starts off, you know, with a doctor doing it, you got a medical opinion says that you can't do any of these things. And so that becomes evidence to the court. And I can tell you from experience, once a doctor does that, fills out this form that says you're incompetent and can't make decisions, and the court sees that, and they have to make a decision about whether or not they're going to put a guardian on you, they look at that document and they pretty much follow it. And once they follow it, they'll issue an order that appoints a guardian for you, and that guardian will, in most cases, be told that they now have the right to make all these decisions for you, and your authority to make those decisions is gone. In most cases, I mean, it just isn't necessary immediately. Because let's think about it, a lot of young people, age 18, with intellectual disabilities are going to stay at home with their parents. They're going to stay in school probably oftentimes till they're 21. And so what is, the purpose of guardianship is to protect you from being abused or neglected or exploited. Well, if you're living at home with your mom and dad who've already been, you know, helping you out with things and taking care of you and making sure that none of those bad things happen to you, there's no reason that can't just continue. Now, you do need to have something to you know, you may need to have something to help with some of these things, but those other things we talked about, supported decision-making, powers of attorney, etc., releases, they can oftentimes be enough to you know, to help other people who are going to interact with you have some belief that that you've legally appointed people to help with decisions without taking those away from you. So you can do that, and you know, as you get older, and like George said, you know, people's brains continue to develop. You use this period of time to practice making good decisions, to learning how to do them, to recognize danger, to recognize potential abuse, to recognize people who want to exploit you or harm you, and then see how that goes. And if it's going fine with using these other tools, you don't ever need a guardianship. And a lot of people don't. I know a lot of people who are under guardianship who probably didn't need to be under guardianship, but it was at the time that, you know, it was put on them, There weren't all these other tools. People didn't know about them, all sorts of reasons why they didn't happen. But you know, what I think you should take away from this presentation is use these other things until they absolutely aren't going to work. See if they work, try them out, do the best you can, and if they really don't work, then consider guardianship. Because the thing about guardianship is all these other things we're talking about, either you can revoke them, they go away, or you know, other people can get rid of them. Typically you can get rid of them. Guardianship's not like that. That's a formal process. It's expensive. There's all these doctors are involved, different attorneys get involved. The court makes an order imposing a guardianship on you, and it's not time limited. It's forever. And the only way you can get rid of it is to go back to court and show the court that you now have regained your competency. And that means that you got to somehow, in most cases, come up with a doctor who's going to say something's different than when the doctor did the first examination on you and said you were incompetent. And that's going to be hard to do. I've looked at a lot of people who want to get out from under guardianships that were imposed on them. And it's hard because, you know, a lot of times the kind of things that doctors look at and consider and the way they do their examinations, may not be a lot of difference from the first one. And they look at what the other doctor said and they're not so interested in saying that the first guy was wrong. So it can be done. You can get rid of a guardianship in some cases, but it's very difficult. Way easier never to get one in the first place than to try to get rid of one once it's imposed on you. So I'm going to turn it over to Lisa so she has time to talk about her situation. But, you know, there's all these other forms. Use them and only resort to guardianship if you have to. George wants it.
Yeah, Mitch, I just wanted to jump in here. Is also with guardianship, you know, if you take that time, and for us personally, it may very well be that we need to do a guardianship in the future, but I can assure you that it would be a limited guardianship. It's not, that's also an option within guardianship that I don't think enough people appreciate, is that you can have a limited guardianship. You can look at different areas that Mitch mentioned, the health, the financial, where you live, and you can put limits on what you give over to the guardian. And then the other one that we're very interested in and think that it definitely has a different capacity standard is voting. And that's one thing that we see a lot of is people lose their right to vote when in fact that they're well competent enough under the voting statutes to be able to vote. And one of the other things, Mitch, I want to remind, do you have the statute so you can read that section? Because I think that's important.
Do I have time, Lisa?
No.
I didn't think so.
Let's give Lisa a shot. But I'll say, we did another presentation on guardianship, and it's on our YouTube page, the BPDD YouTube page. We did another Living Well about a month ago on voting, lots of questions. Let's give Lisa a chance, yes, and then we'll circle back to you two great guys at the end.
There is some questions really quickly before Lisa shares. I think they should be pretty simple to answer. One is about who can be a witness, if you just want to clarify, like, so that if they're going to go down the path of getting two witnesses, who those people can be.
In supported decision-making, it can be anybody. 18
and older.
Yep. Mm-hmm. But it can be a family member, it can be a service provider, it can be anybody. There's no limit on that.
Okay. And then there was another Facebook question that I just wanted to get clarified. It says, if someone has a guardian established and is unable to make a decision regarding voting, can the guardian vote for that person via absentee ballot, or would this be considered fraud?
That's fraud.
But we would encourage them to find out if their guardianship actually has removed
Absolutely.
That person's power to vote.
Find out, because it has to be taken away from you by the court. If they just left, there's a square on the form that the court fills out, the order. And if that box isn't checked, taking away your right to vote, you still have the right to vote.
Right, but that person would have to make the decision to vote absentee
Yes.
themselves.
Correct, yeah. Voting is something that only you can exercise. The guardian can't do it for you.
Right.
We can post the other link for the other Living Well on guardianship, because a lot of those questions were answered there too. So we'll post that link on the Facebook page and the YouTube. All right, I'm going to turn it over to Lisa.
Hey, good morning, everybody. As Sally said earlier, my name is Lisa Pugh, and I'm the Executive Director of the ARC Wisconsin. We are a statewide organization supporting people with intellectual developmental disabilities and have 14 chapters across the state. But just like George, my most important job is that I'm a parent to a young adult with intellectual developmental disabilities. And that's kind of my role here on this Living Well Wednesday today, is to talk to you about my personal experience and to share with you what you might experience if you are a family that's thinking about guardianship. So I am thinking rather about supported decision making. So I'm going to share my screen. And me. And is this looking good, you guys? Can you see the full screen?
Looks good.
All right, perfect. Okay, so as I mentioned, I'm a family member. My daughter, Erica, is 21 years old. And similar to George, we were embarking on that cliff of she turns 18, supported decision-making, lots of pressure to seek guardianship, both. And if you're a family member, you know what I'm talking about. Pressure at the school level, sometimes pressure in the public service community from entities like DVR, certainly from the doctor's office. Oh, this is what we do in Wisconsin. And I think even though the supported decision-making law is a few years old now, was actually enacted in 2018, families are still experiencing this. There are very few people that actually know about this law, and we continue to educate them about that. And families often are those pioneers that are out there saying, I want to do this for my child, which makes it hard, right? Because we are having these conversations with banks and with doctors and challenging kind of what has always been done. So just word to the wise from our experience as a family or an individual who wants to seek supported decision-making instead of guardianship for a young person with intellectual developmental disabilities, you will very likely be a pioneer. You will be in the position of educating people about this law. And so, as I said, expect those obstacles, sometimes with schools, hospitals, banks, and then those systems that really should know better. I think things are changing, particularly in schools, but some of those other systems really are still kind of catching on. So I'm going to share with you a little bit about my daughter, Erica. So clearly she's a Packer fan. Like I said, she just had her 21st birthday, and she fits under that that definition in the law of somebody with a functional impairment. And the one thing that's really great about the supported decision-making law is it defines who can use supported decision-making very broadly, and it certainly doesn't very clearly leave folks out based upon the degree of their disability. It's a very individual decision if you think this tool is right for you. So Erica is somebody who has had a lifelong disability. She does not use her voice to speak, so she uses modified sign language. She uses some assistive technology. She is a very self-determined person. She has very strong opinions about things and gets her opinions across. She lives a really great life. Before the pandemic, she had held a job at a local restaurant for the last 2 years, working about 12 hours a week or so, and we're still waiting to come back to that job. But now she actually is taking over a small business doing some aluminum can crushing and going around the city and the county here and picking up aluminum cans and crushing them and taking them in to be recycled. And so she's a very accomplished young person. We like to kid she has more money in her ABLE and savings accounts than her other brother and sister, certainly her sister who has a lot of college student loan debt. So that's a little bit about Erica, but you can see where she's going into, a doctor's office or a bank, people might not recognize that she can make her own decisions. Now, I'm going to share an example with you of a real life story that we went through with Erica. Erica goes in annually for an under anesthesia neurology appointment and eye appointments because she's at risk for glaucoma. And so right before her last appointment after she turned 18, we got the call. It was already on the schedule. These are very hard to schedule. If you know, when you're meeting with a specialist, particularly something in the hospital under anesthesia, it takes a long time to get those appointments.
Hey, Lisa, you froze.
I'm going to.
Let's give her a second. She told us maybe this would happen. You're still a little frozen.
And you let me know if you hear me magically.
I can hear you now.
You can see me?
Yep, and hear you.
Okay. I'm going to try to call in just so that I have this on backup in case.
Yeah, you sound pretty good now.
ID followed by pound. You are in the meeting now.
Okay.
There are more than 20 participants in the meeting.
All right.
You are muted. You can mute or unmute yourself by pressing *6.
You're still with us. You're good.
All right, I'm turning down. Can you mute? Shoot.
I can mute you. Just give us a second, folks. This is the
I am
wonderful
so sorry.
world.
Okay, so are you hearing?
Unmute your phone. Do it through your phone.
Hello, is my phone working now?
Perfect.
Oh, I'm so sorry. Okay, so this is the scenario at the hospital. This neurology appointment on the calendar, and we get this call. Well, she's 18, so we're not sure we can keep the appointment. It looks like in your file you don't have guardianship. And so here I am in education mode with the nurse from the neurology department. We're pursuing supported decision making. Of course, they have no idea what that is. It's not a box on their form at the hospital. And like guardianship is currently something that they check for in the forms for somebody with intellectual developmental disabilities who they've been treating for many years. And then they said, well, I'm calling because it looks like she used a stamp to sign. See, we had a healthcare power of attorney, one of those forms that Mitch talked about. Wasn't necessarily appropriate to use that or enact a healthcare power of attorney in this situation because Erica is competent to make these decisions. Well, we thought this was before we had a supported decision making. We were in the process of getting the law passed. She used a stamp to sign. Well, then that comes into question. Erica doesn't write her name. She uses a stamp. Again, we're working on supported decision making. So the hospital finally conceded that, well, this is something we might need some education about. It really takes a lot of work on your part as a parent to be that person who's in that education role or a self-advocate to say, this is what I use. This is how I communicate. This is supported decision making for me. I just want to show some little videos. I think, sometimes we as family members have to convince ourselves to know that our loved one is capable of making decisions, and they do decisions every day. And here's just some examples of how Erica, somebody who doesn't use a voice to speak, this is some short video clips of her on her job, actually, telling her job coach what tasks she wants to do and being very clear. You'll see one clip, she's using some modified sign language, and the other one, she's using some accommodations on her job. So I'm just going to show you these quick clips. Oh, shoot. I don't think you're going to hear the audio. I don't think you're going to be able to hear the audio, but I'm
We
going
can
to
see
show
the
you.
signs for sure.
You can hear it? Okay. Here she's using some picture symbols that she has as accommodation for her job to tell her job coach the order of the tasks that she wants to do. So through her modified sign language and just basic accommodations that you or your son or daughter might use in school, whether that be through, like you see there, a piece of laminated material, or through more dynamic electronic assistive technology, there are ways to accommodate people to let them know what it is that they're interested in or what their choices are. One part of the law that I think that was very important to us was the part that said, I, as a supporter to Erica, have the ability to assist her in understanding information and also have the ability to assist her in communicating her decision. That doesn't mean I make the decision for her, but I can be in a role of assisting the doctor to know what her decisions are. If you're like Erica or your son or daughter is like Erica, there's a lot of anxiety about going into any dentist or doctor appointment. So to ask Erica right in the appointment, do you want to undergo this procedure? You might not get the same answer as if you're having a conversation the night before at home about why this is helpful to your eyes, it's helpful to your health. You want to be able to read and look at your devices and to be able to continue to wear your glasses. Yes, yes, yes. Then we need to go to the doctor to make sure the doctor can look at your eyes and keep your eyes healthy. Yes, yes, yes. That's the night before. Then I can go into the appointment the next day and say, here is Erica's decision about today's appointment. So ways to practice supported decision-making is really encouraging your loved one to make those day-to-day decisions, like simple things like what to wear, what to eat, what to do. And you can start this with your son or daughter, your loved one, at a very early age. Sometimes makes daily routines more difficult, but I think it's going to pay off over time as your son or daughter becomes an adult. Discuss the good or bad things that can happen for every choice. Ask the person about the steps that they're taking to make a decision. Help them to think about that. Learning from mistakes. We all make mistakes. That whole term, look up dignity of risk. We do learn from mistakes. And sometimes, when the stakes are lower, that's the time to really be learning from mistakes. Exploring bigger decisions, things that they might want to do on their own, talk to them about that. And then, as I mentioned, explore those assistive technology. And then I think this last point about reviewing the ability to make decisions every year, as both George and Mitch mentioned, we aren't fully developed decision makers when we're 18 years old. We have lots of time to mature. So what have we learned over time as we get older, and how maybe can we grow in our decision-making capacity? Just a word to the wise for parents. Remember that you're not alone. You really are paving the way. As both Mitch and George said, this is going to help to make your loved one with developmental disabilities stronger and ultimately safer. There actually is research out there that says increased self-determination really does protect individuals from abuse and neglect. And I like to think about that as a parent, about when I grow older and I'm just not in the capacity of being with her all the time and protecting her. I want her to have some of those skills as well. And the only way people develop skills is if they exercise them and are growing them and becoming stronger and learning. So I'm hoping that that's working for Erica as she becomes a more mature adult. Don't give up. There have been times where my husband has said, oh, wouldn't it just be easier to have guardianship, because that magic piece of paper sometimes opens doors. No. No, for all the reasons that we've talked about, don't give up. Keep pushing for this. As Mitch said, if your loved one is living at home with you and is going to continue for a while, there really aren't risks, and there's lots of benefits to trying supported decision making. And then just to remember that it's just really important to educate others in the system, and there are lots of good resources available to you to share. Here's just a few of them available from the ARC. These are some new resources from the ARC of the United States, and I know that Caitlin was going to put these into the chat. Just some very simple, kind of plain language ones for everybody to use, where you can look at the information about those different decision-making options, like Mitch talked about, like a rep payee, some other informational releases. What are all the options in front of you? And then kind of thinking more about those myths and the limits of guardianship. And then as you're sitting down with your family, your loved one, to think about future planning and other ways that you can build decision-making into your plan for what happens next in life. So thanks for listening. I'm going to get out of this slideshow and come back to you live, and then we can answer any questions.
All right, that was great. There are a couple questions, and I did post in the chat the guardianship and the voting. Caitlin, if you could do that on Facebook, that would be great. There was just a couple. Somebody had said that they were cautioned that getting guardianship when the person would be older would be much harder. Mitch did answer that's not true, but not sure if there's anything else you want to say about that.
Yeah, I'll just say this, and that is guardianship should always be difficult to get.
Okay.
It should always be difficult to get. But it's not the age of the person. There's no reason why it would be any more difficult or easy to get at that age. It's going to be determined largely by, you know, the medical exam and the circumstances of the person. So that's just not true what you've heard.
The other question, and Lisa, you did kind of answer this, was how does a family with a child with a significant disability decide that their child can make their own decisions, especially when they're not supported by systems around them? So you did have that slide. I think that was, gave a lot of that information. Not sure if you want to add anything else to that.
Well, I would think it depends on the age of the child. I mean, and I think that to think back about how you have practiced decision making and how you're working on it with your loved one, have you really put in places for the person to try decision making? What are the accommodations that they might need? I think that it really deserves a lot of thought before, like as Mitch has said, you're going to say that someone is incompetent to make any decisions. I think supported decision making is just such a great wraparound structure that really can, like I said, it's supporting my daughter to understand the information is my job as a supporter. It's also allowing me to help communicate her decisions. I don't sign the paper, I don't make the decision, but I'm helping her to do that. So I just think it opens a lot of doors for new thinking about who really can and can't. There's no black and white about who isn't able to make decision. You have to use your own best judgment.
And I'm going to give George the last word to wrap this up, since I abruptly cut him off before. You wrap it up for us, George.
Sure. I want to thank everybody for attending, because I think, as Lisa said, we are pioneers. Wisconsin was, I think, the fourth or fifth state to do supported decision making, have a formal law. We're out there changing systems, changing ourselves, giving our loved ones a lot more opportunity. And I think that's critically important. And I guess the thing I'd say is, as someone learns to use supported decision making, I think they get better at it. We all get better as we make decisions. And I'm sure it's in the YouTube video on guardianship. And I caution parents, somebody else is going to get this guardianship order. Chances are it's going to go to somebody else, and you need to think about that. And if your loved one, as I said, we may go with a limited guardianship in the future, but hopefully my son will have experience making decisions and a sense of his own autonomy, a sense of his own self, and what his rights are, that even under those circumstances in the future, he can still advocate for himself and still assert himself to be able to make decisions.
That's great. Thank you so much. There was another question in the chat Lisa did answer, and I'm just going to say that. So somebody said that guardianship is too easy to get, and so how can we help change that? And Lisa said, you know, you really gotta inform other people. You have to talk to people at your county level about what these options are. So, you know, just more information out there about the options and talking about the stories of, you know, getting guardianship and maybe how it was too easy, but advocating for those changes and really looking at that. So we really appreciate it. Next week, we'll be here same time, same place. We are going to be talking about voting. So we're going to have all the ins and outs of anything that has changed up to that day, because we know things are changing all the time around voting. So giving you information about the upcoming election and how you can make sure that your vote gets counted. So join us next Wednesday for that. And thank you to all our great speakers.